Sorry about that. We got in a little late. We'll work on trying to get the people out of here on time before so we can get started. We'll go ahead and call January 11th Fed and State meeting to order. I'm the new chair. Chaired many other committees. I don't think we need to reintroduce our members. I think everybody knows them. Michael Welton is my committee assistant. If you don't know, anybody in the audience wants to get on his distribution list, either stay after or come by the office. He has a pretty good distribution list of all the documents. Let's see, why don't we go ahead and introduce staff? Why don't we start with Jason? Go ahead and introduce your staff and move on to research. So go ahead.
Thank you, Mr. Chairman. Jason Long with the Office of Revisor of Statutes. I'm also joined by my colleague Mike Heim over there with the Office of Revisor of Statutes.
Are we short on spots up here? Mike, just jump up here on the side if you want, or, yep. Okay, thank you. Go ahead, research.
Thank you, Mr. Chair. Andrew Finson, Kansas Legislative Research. I'm also joined with my colleagues, Jordan Mulholland and Leanne Thone. Thank you.
Okay, first thing on the agenda is bill introductions, and since I'm the chair, I've got a couple of my own. As soon as I find them. Actually, let's go ahead. I've got one. My first one's a housing bill. RS is 2569. It's dealing with the RHID districts, just adding a little bit. And, you know, how I'm going to do it is I'm going to make the motion. I'm asking my vice chair to be the second. Try to do that on most bills unless someone wants to make a motion on their own bills, or if you have Democrat bills, you can be the motion and I'll be second. So on that, I would make the motion, and Senator Hildebrand, would you be the second? And if there is no objection to the bill, we'll just consider it passed. Second, okay. Is there any objection on that bill? Not seeing any, we'll consider it passed. My second one is RS 2519. It's a bill. It's kind of like the Angel tax credit, but it's for housing for areas under 60,000. I'll make the motion. Senator Hildebrand seconds. Is there any objection to the bill? Not seeing any. It's passed. I have a third bill. It's RS 2399. And the AFL-CIO asked me to introduce this bill. So do I have a second? Second. Without objection, the bill's introduced. Okay, do we have any other bills to be introduced by committee members? Do we have any bills by members of the public that want to step up? Okay, not seeing any. Them three bills are introduced. Let me get back to my agenda. Okay, we're going to start off with a background presentation. Andrew, you want to start off on medical marijuana. And you have some handouts that you've handed out here. We're going to try to have a briefing, understand what some of the other states have done, and I'll let you go ahead, Andrew.
Thank you, Mr. Chair, Committee. Andrew Finson, Legislative Research. Going to be covering some content relating to the laws around on the federal level and state level relating to medical marijuana. Kansas is presently one of 3 states without some sort of recreational, medical, or low THC, high CBD program, joining Idaho and Nebraska being the other 2 states. However, the 2021 session saw several bills introduced in the Kansas legislature, and one of those bills did get through the Senate Federal and State Affairs Committee, did get through the House of Representatives, and is now in this committee for consideration. And I know Jason will be talking about that in just a little bit. So to Start at the federal level. Marijuana is still a controlled substance at the federal level. And to provide a little bit of historical context, marijuana was very minimally regulated at the federal level prior to 1937. At that time, the United States Congress passed the Marijuana Tax Act, which imposed restrictions on who could access marijuana and who imposed certain taxing requirements, which effectively for the average American made, although not expressly, did make it very difficult to access and essentially illegal at the federal level. The Marijuana Tax Act did stay in effect until, for about 30 years, until 1969, when the Supreme Court in Leary versus United States declared that law unconstitutional due to Fifth Amendment concerns. The federal government, or the Congress, and then acted by repealing that law and instituting the Comprehensive Drug Abuse Prevention and Control Act. When we hear about that act, we typically are referring to Title II of that act, which is known as the Controlled Substances Act. The Controlled Substances Act regulates certain drugs that are found to pose a risk of abuse and dependence, and it recognizes the two competing interests related to drug regulation. So on the one hand, many drugs have useful and legitimate medical purposes and are necessary to maintain the health and general welfare of the American people. But on the other hand, illegal importation, manufacture, distribution, and possession and improper use of controlled substances have substantial detrimental effect on the health and general welfare of the American people. So the Act recognizes those two competing interests. So the Controlled Substances Act establishes 5 categories of controlled substances referred to as Schedules 1 through 5. And a lower schedule number corresponds to greater restrictions, as controlled substances in Schedule 1 are subject to the most stringent controls, where Subject 5 are subject to the least stringent controls. So on page 2 of this document, we have a listing of Schedule 1 through 5, and you will notice that what separates a drug schedule is typically its abuse potential contrasted with its medical use. So you can see the thing that separates a Schedule 1 and a Schedule 2 drug, both Schedule 1 and Schedule 2 drugs are considered to have high abuse potential, but a Schedule 1 drug is considered to have no currently accepted medical value, whereas a Schedule 2 drug does have a currently accepted medical use. So when we talk about what Schedule 1 drugs are, and I do want to point out everything in the examples column, that's just a selection of examples. That is not a full listing on the table. But Schedule 1 drugs include marijuana, heroin, LSD, MDMA, and peyote. Then we have Schedule 2, 3, 4, 5. Getting all the way down to Schedule 5, we have cough medicines with codeine, certain antidiarrheal medications, FDA-approved drugs containing CBD. So because Schedule 1 drugs, including marijuana, are considered to have no accepted medical use, it is only legal to produce, dispense, and possess those substances in the context of federally approved scientific studies. So obviously, we have seen state actions on marijuana, and it has created sort of a growing policy gap between the states and federal government. In 1996, California became the first state to legalize medical marijuana, and today medical marijuana is legal in 36 states and the District of Columbia. In 2012, Colorado and Washington were the first 2 states to legalize the use of recreational marijuana, and today there are 18 states that have legalized the recreational use of marijuana, with several having done so just in 2021. So in those 36 states and the District of Columbia that have legalized medical marijuana, those programs generally provide the following. 1, protection from criminal penalties for using marijuana for a medical purpose. 2, access to to marijuana through home cultivation, dispensaries, or some other system that is likely to be implemented. 3, allowance for a variety of strains. And 4, allowance for either smoking or vaporization of marijuana products, plants, materials, or extract. So another 11 states allow for the use of low THC, high CBD products for specific medical conditions or provide a legal defense for their possession. The states of Florida, Missouri, Oklahoma, Utah, and Virginia have recently enacted comprehensive medical marijuana laws after previously legalizing low THC laws. In Mississippi, a successful ballot initiative in 2020 to legalize medical marijuana was overturned in 2021 by the Mississippi Supreme Court. Page 3 also includes a map that shows all of the states, including their status for legal, recreational, and low THC. Moving on to recreational marijuana use at the state level. So a total of 18 states and the District of Columbia have legalized the recreational use of marijuana. Of those 18 states, 7 did so through the legislative process. Those bills went directly through the legislature, while the remaining 11 states did legalize recreational use through a ballot measure. In South Dakota, a successful ballot initiative in 2020 to legalize recreational use of marijuana was ruled unconstitutional by a circuit judge in 2021, and that decision was upheld by the South Dakota Supreme Court. So looking at regional medical marijuana laws and low THC program laws, in our region, obviously Nebraska does not have legal medical marijuana, recreational, or low THC, so they're not included on this grid. And just of note, Iowa is included, but just to point out, that's a low THC, high CBD state. You can see the general characteristics of those 5 states. Typically have some sort of patient registry or ID card, do allow for dispensaries, specify the conditions that qualify for medical marijuana usage, and then recognize patients from other states. All of those states except for Colorado do that. And then conversely, all of the states except for Colorado prohibit retail sales or non-medical use. So a point to spell out with a little bit more specificity when we say this states what they recognize as conditions, qualifying medical conditions. Just looking at Missouri as an example of what conditions qualify for medical marijuana access, the Missouri Constitution lists the following: cancer, epilepsy, glaucoma, intractable migraines, chronic medical conditions that cause severe persistent pain, such as Parkinson's and Tourette's, debilitating diagnosis psychiatric disorders such as PTSD, HIV or AIDS, a chronic medical condition that is normally treated with prescription medication that could lead to physical and psychological dependence, any terminal illness or any other debilitating condition, including hepatitis C, ALS, IBS, Crohn's disease, Huntington's disease, autism, and obviously several other diseases listed there. So moving on to regional medical marijuana licenses and fees. The fee structures do vary greatly by state, but typically fees and licensures required of distributors, dispensaries, patients, caregivers, laboratories, and processors. Marijuana application and licensing fees can be set by statute or regulation, often including caps or guidance in the statutes. So on the back page of your memo, we have a regional review for Arkansas, Colorado, Iowa, Missouri, and Oklahoma. And you will see that there's a fair degree of variance in some of those fee structures. That has to do in large part of the way the different states are set up in their fee structures. Arkansas, for example, limits the number of dispensaries and the number of cultivators. I believe there's only 8 cultivators that are authorized in the state of Arkansas and up to 40 dispensaries. So you see that their fees are very high, or could be considered high, because they limit those numbers. Missouri ties their fees to evaluation every year based on the Consumer Price Index, and so their fees are subject to increase or decrease every year as well. But hoping that this document will be a resource for you as you have this discussion, and would be happy to answer any questions from committee at this time.
Sure. Thank you, Andrew. Is there any questions for Andrew? Senator Longbine?
Andrew, in conversations with some of the proponents of this, I've had Ohio as a state that maybe we should look at. Would it be possible to update this chart on the back sheet with Ohio's licensing information also?
I can certainly get you that information, yes.
Okay, we'll work on that. Senator Fasco-Doe?
Thank you, Mr. Chairman. Andrew, thank you for the thorough presentation. So of those 36 states that have passed some type of laws dealing with medical marijuana, and so in Colorado, so they've been one of the 2 states that implemented the laws first. Can you tell me any pros or cons of the implementation or the legalization of medical marijuana in Colorado?
I would maybe have to follow up with you. I wouldn't want to speculate as to what those states see as pros or cons. Obviously, I think the revenues generated from those are typically considered pros of implementation. But I don't have those exact figures in front of me, so I'd be happy to follow up with some of that information.
Thank you, Andrew. Mr. Chairman.
Other questions or comments? Senator Reichman?
Thank you, Mr. Chairman. Appreciate that. And thank you for the presentation. Mine just kind of a general thing. As I talked to different people, I had 2 different comments, and I just soon get one from you. Concerning Oklahoma, I live 25 miles from the line in Oklahoma, and I have people say that there's dispensaries, or you can buy it all over the place in Oklahoma with signs and so on. And I didn't know if that had to do with the last one about how you set it up by how many you can have and so on. Then secondly, I was talking to another gentleman in Denver, and he was saying that he noticed when he goes out there, there's a lot of tent cities of young people that he's never seen before, and those are just anecdotal, and I was just wondering if you could respond to any of those 2. Thank you.
Sure, I could. Thank you for the question. I could certainly respond to the first. You're right that a lot of that has to do with the structure that the legislature would ultimately decide. As I'd mentioned in Arkansas, in addition to having those limitations of number of cultivators, I believe they also have them restricted to certain districts. So there can only be 3 dispensaries in District 1, 3 in District. So that is a structure that the legislature could consider, as opposed to opening dispensaries up just statewide. But that's a policy decision. I don't think I necessarily have any insight or comment on the 10 cities or the latter at this time.
And one of the things I did do a little bit of touring the last 5 or 6 weeks of and talking to a lot of people that are in this industry, and the thing I heard repeatedly is Oklahoma was probably not what we want to be by far, and I don't know how to say it outside of, they were really laxed on their regulations and allowed for a lot of the dispensaries and not a lot of controls. So, I hope, when we look at Oklahoma, it's probably what we don't want to do. So, Senator Hosher?
Thank you, Mr. Chair. Thank you for the presentation. I was just going to ask specifically in regard to what was asked by the senator to my left, Fascato. Could you please include the revenues generated for the states when you're updating also with the information Senator Longbine asked?
Absolutely, would be happy to get you that. And if there's additional information the committee would provide, happy to, if you reach out and request that, we'll get that information for you.
Senator Fascato.
Mr. Chairman, I just have to point this out. You and the Vice Chair, Hildebrand, you have matching ties. Did you plan that?
No.
Oh, wow. So, and Andrew, only if the medical marijuana would cure or be helpful for COVID, that would be pretty amazing. But anyway, thank you again for the presentation.
Other questions? Thank you, Andrew. And if you can, anybody wants follow-ups, work through Michael. That way everybody gets them, or your responses as they come back. Try to get everybody equally the information so they have. Okay, we'll move on to Jason Long, reviser. He's going to give us a comparison of the two bills we have and explain them a little bit. Kind of give us a little background on what happened in the House or
Sure. Thank you, Mr. Chairman. What you have handed out in front of you is a comparison chart comparing what is now Senate Bill 158 as it came back from the House and comparing it with Senate Bill 315, which was introduced at the end of last session and referred to this committee and has not had a hearing or any work on it. Senate Bill 158 did have quite a bit of work over in the House. They had several days of committee meetings in House Federal and State Affairs in which they largely amended the bill. It then went to the floor. There were a number of floor amendments that were added onto the bill during the floor debate, and then it came over to the Senate in this form and was referred to Federal and State Affairs here in the Senate. That is the bill I'm going to largely focus on, going through the comparison sheet. I did, however, just want to do, I was requested actually during the interim to do a comparison of the two bills, and I thought it would be beneficial for the committee members to have a comparison with the Senate bill that was introduced and referred to this committee at the end of last session, just for comparison. You'll see a lot of the provisions are the same in the two bills. There are just a few substantial differences that you can note. The bill, and this is not to Senator Longbine's question, is structured off of the Ohio model in regulating marijuana, in which they broke up the different regulatory pieces and assign them to different state agencies to oversee different aspects of the cultivation and sale and use of medical marijuana in Ohio. And so Senate Bill 158 does the same thing. It follows that pattern that it has KDHE regulate the registration of patients and caregivers and getting those identification cards, having the written recommendation from their treating physician that qualifies them for the use of medical marijuana. And so that's handled on that end. In conjunction, and then ABC, which is actually in the bill renamed to the Alcoholic and Cannabis Control Division, would monitor the business regulation of medical marijuana. The cultivation, processing, distribution, and retail sale would all be regulated by ABC, much in a similar fashion to how they regulate alcohol production and distribution and sales under today's current laws. The third regulatory entity is the Board of Healing Arts. So the bill requires any physician who wants to write a recommendation for treatment with medical marijuana must go and get certified by the Board of Healing Arts. and go through some requirements I'll go through a little bit later to maintain that certification and continue treating in that fashion. And then finally, the Board of Pharmacy plays a role in that the retail dispensaries would be required under the bill to contract with a pharmacist consultant. And that pharmacist consultant must be registered through the Board of Pharmacy. The Board of Pharmacy also is in charge of the monitoring program, the prescription monitoring program, and there's reporting requirements to that prescription monitoring program when treating with medical marijuana. I will note on this first page of the handout, you'll see state preemption. This is very similar to alcoholic liquor in that the state is preempting the regulatory field, except for one narrow local exception. The state law is the exclusive authority for growing, harvesting, producing, selling, transporting, delivering, furnishing medical marijuana in the state of Kansas. The regulatory entities are going to be assisted by what is being created in the bill as a Medical Marijuana Advisory Committee. This would be a 15-member advisory committee with interested stakeholders making up the membership of that committee. Members would serve for 2-year terms. One of the primary duties would be to develop policies and procedures for allowing the Secretary to review, Secretary of KDHE to review and add or remove what are qualifying medical conditions for the use of medical marijuana. They're required to review that list every 3 years and make recommendations. They're also going to make recommendations on those criminal offenses that would disqualify an individual from a business license under the Act. They are required to report annually to the Legislature, and they did receive a sunset under this bill of 2026. Note all the dates in this bill are as if it were to be enacted last year and based on that. And so the committee might consider moving all the dates, 1 year if they want to keep the same policy of allowing like a 2-year rollout before it fully goes into effect. You'll want to move the dates 1 year to do that. The regulations, the healthcare side of it with the healing arts and the Board of Pharmacy, they would be required to roll out regulations by July 1st of 2022. KDHE for the patient and caregivers, and ABC for the businesses, get an extra year for doing those regulations. So the whole package doesn't really go into effect until July 1st of 2023 because of those regulation dates. There is a requirement that on that date, July 1st, 2023, KDHE have a public website up and running for patient and caregiver registration. And then I just wanted to point out there are some key definitions in the bill. Marijuana is as we define it under our Uniform Controlled Substances Act currently. There is a definition of a medical marijuana product to cover those different products that are processed and then sold through the Act. I will bring attention to the qualifying medical condition. You can see it's a fairly extensive specific list there on page 3 of the chart. If you flip to the next page, you'll see there are 2 catch-alls at the bottom. It also includes any other pain that is chronic and severe or intractable. And that, of course, be based on the diagnosis and written recommendation of the treating physician. The other is any other disease or condition that's added to that list by the Secretary of Health and Environment based on the recommendation of that advisory committee. So there are a couple additional provisions there that would extend that list potentially, or as I may note, the bill does provide for removing medical conditions from that list based on the recommendation of the advisory committee and the act of the secretary. You can note over on the right-hand side on page 3, there is a comparison with that list in Senate Bill 315. It does differ slightly from the House's version in 158. Getting into the actual medical marijuana use here with patient and caregiver registration, I will note the treating physician applies to register the patient and certifies that the patient has a qualifying medical condition. So there's that first step of the application process to KDHE. The second part of it is the patient or the caregiver must also apply to get their identification card that they will have to show at the retail dispensary to obtain the medical marijuana product. So you have a two-step process there to get patients and caregivers registered with the state and to get them their ID card. There are limits under the bill as to the forms that you can acquire medical marijuana, oils, tinctures, plant material, edibles, patches, and then there is an authority for the Secretary of Revenue based on recommendation of the Director of ABC to approve another form for a retail dispensary to dispense. The caveat to that is the bill does prohibit smoking or combustion or any other type of vaporization of marijuana. Those forms are not permitted under the bill. There are also some limitations on the THC content, and if you noticed on the previous page, there is a specific definition of THC under the bill. Plant material can have not more than 35% in the final dispensed form, whereas extracts have not more than 70% in the final dispensed form. And then finally, you'll note the patient is limited to a 30-day supply before they have to go back and get a refill on that product. The bill specifically prohibits cultivation by a patient. A patient or caregiver identification card does not give you the legal right to grow your own marijuana for your own personal consumption. There are then provisions for minors, persons under the age of 18, to obtain a patient registration. They have to get a parent or parental guardian consent to treat, and their parent or guardian must be designated as the patient's caregiver. The caregiver requirements on page 6 there at the top, you have to be at least 21. Unless you are the parent of the patient, in which case you still must be at least 18 or older to be the caregiver. A patient can designate up to 2 caregivers so that there's a backup if they need assistance in being administered the medical marijuana. And a caregiver can serve up to 2 patients. They can apply for an exception to that with the secretary, but the baseline is 2 patients. And a recommending physician cannot serve as the caregiver of the patient that they are making the recommendation for. Fees for that patient and caregiver ID are there in the next block. $50 standard for a patient ID unless you can prove indigence or that you are a veteran, then it's only $25. The caregiver ID is only $25. And those licenses are good for, those ID cards are good for 1 year. So that's basically an annual expense to get your new ID card. There's a fund created to help regulate all that and pay for the costs of KDHE and administering this part of the act. There are provisions for specific 24-character ID numbers to be issued to each patient and caregiver so that it can be validated by the retail dispensary through the state. And finally, there is reciprocity provision so that if you have an ID card, we'll recognize non-resident patients to possess medical marijuana, and the same as recognized in Kansas. So we have reciprocity with other medical marijuana states under that provision. I can stop there for questions, or I can just keep continuing and feel free to interrupt.
Anybody have questions? Senator Fasquedo.
Thank you, Mr. Chairman. Thank you, Jason Long. So the prescription monitoring program, how does that work? I mean, how are they monitoring it?
So I was going to get into that with the physician being required to report their recommendations to that program. It's not a prescription because, as Andrew stated, marijuana is a Schedule I federal drug, and so nobody prescribes it because there's no certified medical purpose for it. And so it's not a prescription in that sense, but the Act is using that prescription monitoring program to track physicians who are recommending recommending its use as a treatment and submitting those written recommendations for patients.
And Mr. Chairman, Jason, so elaborate just a little bit more on the part where you said that the physician has to report the name of the patient who has a medical issue to get the card, and the patient has to do the same, but what's the difference?
Yes, so the physician will submit a registration application on behalf of the patient, and if the patient indicates they're going to have a caregiver at that time, would be on behalf of the caregiver as well. And that would be an application indicating this patient has this qualifying medical condition, and I'm recommending, this treatment with medical marijuana
The
to
healing
KDHEs.
arts. To the healing arts.
To health and environment, to KDHE. And then at the same time, the patient and the patient's caregiver, if there is one, would submit an application for an ID card. And so then KDHE marries the written recommendation with the ID card application, and then would send an identification card to the patient and the caregiver in that instance.
Senator Reichman.
Thank you very much, Mr. Chair. This probably shouldn't go to you, but the first, when Andrew spoke, is talk about the schedules, 1 through 5 and whatever, and it has marijuana as a Schedule 1. Now, these schedules, do these come from the federal government? Or if they wanted, let's say, move it to Schedule 2, how would that have to happen?
It's federal law, and so you would have to have an act of Congress to move marijuana from Schedule 1 down to one of the lower schedules.
Okay, thank you. And then when you're talking about qualifying medical conditions, it's got quite a list where it says that it can help them. Is there a debate how much if it does help them? The reason why I was asking, I was talking to it doesn't matter, a professional, and he said that marijuana did not help in the glaucoma. And of course, that was, I guess, his opinion. But they have quite a bit of list here. How do they come up with this list?
I'm not sure what the source of this list was. I know the list out of Ohio, I believe, is relatively extensive like this. So that may be in the source. I'm not sure. I do know, I point out again, that the bill provides for that advisory council, that 15-member advisory council, to review that list at least once every 3 years and make recommendations as to whether or not any of those conditions should be removed from that list, and then grants the secretary the authority to discontinue one of those qualifying medical conditions based on that recommendation of the council. So there is a review process. Because there is a difference of opinion potentially as to whether or not medical marijuana can be a useful treatment for some of these conditions.
Thank you, Mr. Chairman.
No problem. Nate Hosher.
Thank you, Mr. Chair. I recognize that some people don't have PCPs or longstanding relationships with a physician. Do either of these bills have the stipulation that there has to be a certain time frame of a relationship?
Yes, I was getting into, that was the next segment of the presentation, was to get into the physician's, more into the physician's role in that, but there is a time period of relationship required generally.
Very good, thank you.
Other questions? Go ahead.
Okay, moving on to page 7 of the chart. This deals with the physician certification and some restrictions on treatment by a physician. As I noted, the physician has to obtain a certificate from the Board of Healing Arts if they're going to make a recommendation to treat with medical marijuana. They require annual reports to the board by the physician on observations of the effectiveness of the treatment, and this would probably go towards somewhat of the senator's question on on the efficacy of the treatment with respect to certain medical conditions. They also must annually complete 2 or more hours of continuing medical education on the treatment and use of medical marijuana, and there is an annual fee for their certification. Getting to Senator Holscher's question, generally the physician must have an ongoing relationship with the patient for 6 months prior to recommending treatment with medical marijuana. There are a couple of exceptions. One, the patient has moved in from outside of the state and has a recommendation in a medical marijuana state already when they move into Kansas. Two, they have a recommendation and are changing physicians. And so if you have a change and you already have an existing recommendation, or if the patient is a veteran, there's an exception to that 6-month waiting period as well. However, the physician must still conduct a physical exam and review the patient's medical records, must report the recommendation to the prescription monitoring program. And then there are limitations on how long that recommended treatment is good for. It's going to be up for 90 days. And then they can renew that 90-day period for 3 additional 90-day periods. But they must conduct a new physical examination of the patient within the year, within every 360 days. There's also the reiterated prohibition on recommending treatment for the physician's self or any family member of the physician, or dispensing medical marijuana himself or herself as well. Dispensing can only be through the retail dispensary. Moving into the business facility regulation aspect of this is the regulation. That was all KDHE and Board of Healing Arts regulation. Now we're moving into ABC's area of regulating the business facilities. There are some general license application requirements for a business facility license. You have to get a separate license for each location that you are running. That's very similar to alcohol regulation. You cannot have an ownership interest in or share employees with a licensed laboratory unless the application is for a laboratory license. And so this is to distinguish the laboratories and give them kind of a separation on that conflict, because the laboratory are the ones doing the testing for contamination and quality control for the business facilities. And so there's intended to be a separation in ownership there. The license applicant must conform to all location restrictions, have a tax clearance certificate. Cultivators, those who are growing, must demonstrate that they can grow in a secure indoor facility. I will note cultivators grow indoors to lessen the chance of contamination of their product when it gets sent off to the lab. They have usually a very tightly sealed, controlled indoor climate controlled environment to do that growing. And then there's a provision that not less than 15% of the business licenses must be issued to minority applicants. The ownership restrictions on the licensee, there at the bottom of page 8, must be a U.S. citizen, must be at least 18 years old, must be a Kansas resident for the past 4 years. I will note in the liquor regulation area, there was a recent Supreme Court case that called into question the constitutionality of residency requirements, particularly struck down residency requirements on liquor regulation. And so there might be a question as to whether or not that would apply to a residency requirement for a medical marijuana business application. I'll just note that, but we don't have anything specific on point thus far in the legal area. There are restrictions if you've been convicted of a disqualifying offense or had a medical marijuana license revoked. Can't be a law enforcement officer or be an employee of ABC. And you cannot have an undisclosed beneficial interest in another licensee. So you got to disclose all your interests to ABC in applying for the license. It can't be a publicly traded company, and you have to verify the individual owners satisfy all the eligibility requirements. There is an exception to the Kansas residency requirement. Only 75% of the owners of the enterprise have to be Kansas residents for 4 years. And then there's a restriction on compensation agreements. that they cannot be contingent on sales revenues or cash flow of the licensee. You have to be a fixed salary compensation arrangement. There are also location restrictions on these business facilities. Can't be located within 1,000 feet of any school, church, library, or park. Obviously, if you're already in existence prior to the establishment of that school or church, you can remain at your current location if permitted by the director. The one local regulation I will point out at the bottom of page 9 of the chart, the House put in a provision that the Board of County Commissioners can adopt a resolution prohibiting a licensee from operating in that county. Any licensed facility operating prior to the adoption of such resolution could continue operations and would not be subject to that resolution. But there is that measure of local control at the county level. On page 10, there are extensive provisions in Senate Bill 158 regarding advertising and signage for medical marijuana. This includes requiring the Board of Healing Arts to adopt regulations for signage of retail dispensaries that include proper warnings for pregnant women and individuals with psychiatric or emotional disorders about potential adverse effects of using marijuana. There are limitations on cooperative advertising between 2 or more licensees so that they don't influence the choice of medical marijuana product. There are outright restrictions there in the middle of the chart on certain forms of advertising. These are general consumer protection restrictions. All advertising has to be submitted to ks.gov for approval. Retail dispensaries cannot advertise specific brands or use graphics or exterior signage or display any product or paraphernalia visible from the exterior. So there's no outward displays on the exterior of the building of medical marijuana products or means to use them. The price cannot be advertised by cultivators, processors, or distributors. And prices cannot be advertised on any highway billboard. And marijuana cannot be advertised on any highway that is within 10 miles of the state line if the highway crosses the state line. So some extensive advertising restrictions there under Senate Bill 158. Next, I'm going to get into more of the actual licensee types and what they can do. Page 11, there are cultivation or growing facilities. These are growing the marijuana and then delivering it to licensed laboratories, processors, distributors, or retail dispensaries. It must be tested for contamination prior to being delivered or sold. There are limits on the area that can be expanded upon application to ABC to get a larger growing crop. And the licensee cannot grow medical marijuana for personal or family use and cannot do so on public land. So there's that no growing for personal use restriction again. In terms of laboratory testing, there is a provision on Senate Bill 158 that has ABC director contract with a private laboratory for compliance and quality assurance testing required by state agencies. So this is like a state contractor laboratory, separate from the licensed laboratories. It's just a separate private contract that ABC will be entering into to help with developing testing and research practices and protocols and to do testing for state agencies. Then there is the actual laboratory licenses that are issued by ABC. These are to facilities that are going to conduct the testing on behalf of cultivators or processors or distributors to ensure that the product meets state requirements for sale. Processor facilities at the top of page 12. These are the facilities that are authorized to take the raw medical marijuana material and process them into one of those forms that can be then dispensed to a consumer, such as an oil or tincture and edible. So they can sell those to other licensed processors, distributors, and retail dispensaries. Distributor facilities, these are basically taking and packaging those products and then storing them and distributing them to retail dispensaries that are licensed with the state. Both of those facilities must comply with the packaging and labeling requirements under the law, so that's clear identified what the product is, THC content, et cetera. And then finally, there's the retail dispensaries. This is the endpoint for the consumer where the product goes and then is dispensed to a patient or a caregiver when they present the identification card. All sales are reported to that prescription monitoring program database, so there is a record of all those sales. The packaging requirements are there, including packaging that it must be child resistant and tamper proof. You cannot dispense medical marijuana through a vending machine or via electronic commerce. The patient or caregiver must come into the dispensary licensee premises and purchase the product there. And then 2 additional requirements under 158. All employees of a retail dispensary have to be licensed by ABC. And the retail dispensary must have a pharmacist consultant contracted and registered with the Board of Pharmacy with the state on their staff to consult with. I will point out that educational research facilities that are doing testing at, say, like Kansas State University or University of Kansas on medical marijuana and the use of marijuana are all exempt from this regulation by the state. They have their own protocols as research universities that they have to follow. Page 13, you'll see the facility license fees there. These are generally all annual fees. The retail dispensary license is a 2-year license. The other ones are all 1-year licenses. And so I believe the retail dispensary license would be a biennial fee, but I'll have to double check on that and make sure of that. It's not real clear under the bill. There is a regulation fund established for ABC's use to collect those fees and pay for the cost of regulation and enforcement of the business facilities. On page 14, you'll see some additional provisions regarding this business process. The director is required to establish and maintain a statewide tracking system. This is a seed to sale tracking system that tracks the product from when it's grown by the cultivator through the processing, distribution, and retail sale of that product. There's also the director may establish a payment processing system coordinated with the state treasurer that would allow the ABC to track the transactions, the actual monetary transactions through the system and make sure they're all in compliance with state law. And then you note on page 14 there in the middle, the employee licensure requirement. These are associated key and support employees, which are all defined under the bill at various levels of responsibility within the retail dispensary, and the licensure fee for each of those employees. And those licenses are 2-year licenses as well. And then finally, the pharmacist consultant has to register with the Board of Pharmacy. And there are some limitations on the compensation that the consultant can receive from the retail pharmacy for their services. With that, and then one more point I wanted to make, Mr. Chairman, before I break for questions. The House put in a provision to create a pilot program. So before licenses are dispensed and patient ID cards are necessarily handed out, the director will select one company for the pilot program. They will issue that company one type of each business license and enter into a private-public partnership with a state university to develop some best practices on regulating the product. And basically, that one company will serve as a pilot for cultivating, processing, distributing, and then eventually dispensing to patients and caregivers medical marijuana. So there is that pilot program provision, and that would occur within 45 days after the effective date of the act. This pilot program would be set up under Senate Bill 158. I'll be happy to break for any questions if there are any on the business regulation aspect.
Question, Senator Hosher.
Thank you, Mr. Chair. Thank you. In regard to the section retail dispensaries, is there any language in either bill that clarifies anything in terms of the design or the names for the products so they're not like enticing to children?
Yes, I believe under the, let's see, I believe under the forms of advertising, you can't portray any symbols associated with minors. You can't target to minors in that aspect. In terms of the actual product labeling itself, I don't recall specific restrictions other than what must be included on the product label. I'd have to go back and check on that.
Go ahead.
In regard to the cultivation facilities, so there's a plant limit in SB 315, but not in 158.
Not that I recall. I can look real quick.
I didn't know if maybe there were any parameters in regard to the size of the facility, maybe in 158.
I do not see a reference to any size of the facility in the statute on cultivator, in the section on cultivator licenses that I'm looking at right now. I can look through the bill and see if there are any other limitations on that, but I do not, there might be one in the definition. Hold on.
There's a limit, but is there a floor?
I don't see one, no.
Okay, thank you.
Jason, I got a quick question. Growing dispensaries, all that. In the Missouri version, they have camera angles. They're supposed to have 2 cameras on, be able to see every plant, every aspect of the building, inside out. Does this bill have anything like that in it? And the state can see them cameras in real time?
I don't recall anything that specific in 158. The licensed applicant has to demonstrate that their facility is secure, but I think it might be left to regulation as to what constitutes secure. The Missouri was a initiative. They passed medical marijuana by initiative and had some I think lengthy regulations as part of that initiative, but I don't recall anything of that specificity in 158. I can double check though.
How about the transport, once, you get the, it's been put in its form, final packaging, who can transport that? I know Missouri has pretty strict regulatory over who can and can't.
I know other states have a special transport license or permit for transporting products. I believe under 158, your authority as a business license allows you to deliver that product to another licensed facility. So it allows for the transportation.
Okay.
Now you would have to be, an employee of that facility, because obviously if you get stopped by law enforcement, you want to be able to present, your legitimate order, your facility license, and all your documentation showing that you have the right under the act to transport the material.
Okay. Further questions? Senator Reichman.
Thank you again, Mr. Chair. Just a couple quick ones. I'm not quite sure how to ask this, but looking over like for ads and so on, it said they had to be approved. And then like in Colorado, they have big signs, if you want medical marijuana thing, call me, billboards and that kind of stuff. Would we have that, or could we either it is KDHE must approve it. Would that be through them if a physician could do something like that or not?
My understanding, I didn't read the provision as authorizing KDHE to impose limitations on placement of ads, more content of the ads, to make sure it wasn't false or misleading advertising, or they weren't advertising a price when they shouldn't be under the law. There are some location restrictions in the bill, such as you can't advertise prices for marijuana on a billboard, and you can't advertise medical marijuana on a highway that's within 10 miles of the state line. So there are some placement restrictions there. But I think KDHE is more content restrictive.
And could I just follow up with?
Sure, go ahead. Senator Reichman.
This is a different off the, and I was talking about for licensee applications requirement. And I'm not for or against it. I just noticed that it says not less than 15% of license must be issued to a minority applicants. I was wondering if that was normal, and how did they come up with the number 15%?
I believe that comes from the Ohio Medical Marijuana Regulation Act. They have a provision like there to encourage minority-owned businesses, and so I believe it was lifted from that statute.
Thank you, Mr. Chair.
Thank you. Further questions? Go ahead, Jason.
All right. I'm on page 15 of the chart, getting into taxation and revenue distribution. So several other states will impose an excise tax on medical marijuana or recreational marijuana at either the various levels or at least at the end consumer at the retail point. Under 158, there are no excise taxes. Simply, there is a state sales tax rate applied to the retail at the retail transaction that will be collected. There could be additional local sales taxes. This is just all covered by the general sales tax laws in Kansas. And note, there is no pharmaceutical exemption for medical marijuana products because it is not based on a prescription. It is a written recommendation. And so the sales tax rate for that location where the retail dispensary is located is what would be applied and collected and remitted to the state. And then the distribution, it's what it follows the same as state sales tax revenue distribution is currently. There's no special provisions for allocating or earmarking a particular amount of revenues under Senate Bill 158. It does exempt medical marijuana from those taxes that are imposed on controlled substances that are controlled illegally. We do have that tax, and medical marijuana would be exempt from that because it would be a legal substance to sell under the act. The next section I'm going to get into, there are a number of provisions that I kind of titled non-discrimination provisions, and these are basically protections for individuals with a patient or caregiver ID card or a medical professional involved in writing a written recommendation for treatment with medical marijuana. And so you can see there's nothing under 158 pertaining to real estate transactions, although there is a provision under Senate Bill 315. But you'll note a person can't be denied custody or visitation time because of their being a registered patient. A physician, physician's assistant, a nurse, certified nurse midwife, none of those should be subject to disciplinary action solely for engaging in activities related to medical marijuana. So if they're able to write written recommendations or they work for a physician who is treating with written recommendations, the Board of Healing Arts or the other applicable regulatory board cannot take disciplinary action against those individuals. There should be no discrimination in organ transplant awarding because the person is a registered patient. They can receive an organ transplant and cannot be discriminated against based on that criteria. There's a restriction on anybody that determines qualifications for a license, a certificate of registration. They can't require a person who is a registered patient to disclose that information, and they can't disqualify a person from licensure or certification based solely on their being a registered patient. There are some exceptions to that, as you can see, under the Peace Officer Standards and Training Act, Highway Patrol, Board of Healing Arts, Board of Pharmacy, KDHE, and ABC can all, of course, identify a conflict of interest there. Under page 17, there's employment provisions. And this actually allows employers to restrict possession and use of medical marijuana on business property and may restrict the consumption of medical marijuana by employees while engaged in performing their work duties. They may also impose a workplace drug policy that includes testing and discipline for violations. So there's no restrictions on employers in terms of their engagement. However, if you note right below that, if a person becomes unemployed, they are not disqualified from benefits if terminated for misconduct, and misconduct is based on the possession of a patient ID card or possession of medical marijuana, and they're a registered patient. So if they're terminated pursuant to that, they can still file for unemployment benefits. Also, a person would not be disqualified from refusing to participate in a substance abuse program if they're a registered patient. And then finally on that page, you can see workers' compensation cannot be denied if the employee is a registered patient and they were using it in accordance with the Act, and no prior incidents of impairment on the job in the past 2 years. So there's some protections there for employees. Page 18, a few other, these are the criminal code provisions in Senate Bill 158. It is a Class C misdemeanor to transport medical marijuana unless the product is packaged and sealed as required by regulations. It's locked in a compartment and inaccessible to individuals in the vehicle, and the product is in the possession of a passenger who cannot be, or is in the possession of a passenger who cannot be directly accessed by the driver. So there's some regulatory precautions there when transporting medical marijuana products. There is a new crime, makes it a Class A misdemeanor to leave medical marijuana accessible to minors. There is a provision that protects financial institutions from criminal liability for providing services to licensed business entities. The bill does decriminalize medical marijuana use, so no criminal liability for possessing or transporting medical marijuana in accordance with the Act. There is also a lowering of the penalty if you're not a registered patient or caregiver, but you do have a written recommendation from a treating physician and possess not more than 1.5 ounces. There's a lowering of the fine there. And then finally, they have a provision under Senate Bill 158 that a law enforcement officer cannot enforce a federal firearm prohibition against a person who is using a controlled substance if they're a registered patient and their substance is medical marijuana being used in accordance with the Act. A couple of housekeeping things. The division is being renamed under the bill, Division of Alcohol and Cannabis Control. And then finally, I want to point out the Senate Bill 158 has a section of statutes right in the middle of it that will look repetitive if you ever, want to read the bill on a late night having trouble sleeping. There is a contingency provision that if the federal government were to pass an act that removes marijuana from Schedule 1, so down in one of the lower schedules and could be prescribed, then those provisions of the act that refer to a written recommendation would then be amended to refer to a prescription, and it would be all based on a prescription rather than a written recommendation. And so in the event that contingency occurs, there are already amendments written into the bill that would go into effect on basically verification that the federal law had passed moving marijuana from a Schedule 1 controlled substance. With that, I'd be happy to answer any questions, Mr. Chairman.
Okay, question, Senator Hildebrand.
Thank you, Mr. Chairman. Thank you, Jason, for your in-depth explanation. So the one area that really caught my attention when I was reading through your explainer was enforcement of federal firearms law. So hypothetically, it says no law enforcement officer may enforce the federal prohibition on firearm possession. Can you explain that a little bit further on what enforcement would entail?
Well, there are certain restrictions on possessing a firearm while under the influence of a controlled substance that could result in criminal penalties for the individual. And what I understand this provision is doing is prohibiting that that enforcement if the person is using medical marijuana and happens to be in possession of a firearm at the time and is stopped by a law enforcement officer.
So the law enforcement officer would not be able to confiscate a firearm at that point?
I do not believe so. If no law is being violated, then they wouldn't be able to. I can certainly look into that a little bit more. I didn't write that provision. That was added in on the House side, so I can look at that a little bit more and see what was the intent of that provision. That was my understanding of it. But let me look in terms of the seizure aspect of it and see what that entails.
Because I'm really curious, because federal law still says it is illegal to own, purchase a firearm or ammunition. So federally, they could still do it. And law enforcement might not be able to enforce it, but could they assist?
And so this does not apply to federal agents, because state law cannot impose any restrictions on federal agents imposing federal law. This is, I'm reading the provision now, it's law enforcement officers defined under the state peace officers standards and training statute shall not enforce any violations of the federal firearms laws if the substance involved is medical marijuana and the person is a registered patient under the act.
But could a Kansas state law enforcement official assist a federal law enforcement official on enforcing federal laws?
That would probably come down to your definition of what constitutes enforcement. Is assistance constitute enforcement of the law?
Taking that one step further, and thank you for clarifying that, because that's what I thought as well. But let's say, for instance, that says law enforcement. Let's say somewhere down the road we have an administration that's not very friendly toward gun owners. We have this system in place that the Secretary of Health has all this data and information. And what if the Secretary of Health decided that it was a health issue that someone that had medical card should not be in possession of a firearm? They're not law enforcement. Could they then issue a mandate to turn in your firearm?
I don't think the Secretary has that authority currently. I think you would need some kind of state law passed to give the Secretary of Health and Environment that authority in order to seize someone's firearm that was lawfully being possessed.
Wouldn't be lawfully possessed at that point.
Well, only if there is a state law that prohibits possession by a person who is a registered patient and possessing medical marijuana.
Could a governor issue an EO?
There would be some questions about the authority of that EO, I'm sure.
There's always questions about the authority of EOs, but that doesn't stop them from being written and enforced, so.
And your hypothetical, I believe there would need to be some additional state law authority for the Secretary to act in that manner. I think any executive order giving that kind of authority to the Secretary would be challenged. I don't know what the outcome of that challenge would be, but I think it would be called into question.
Okay, thank you.
I'm sure you've looked at other states and there hasn't been anything like that tried either.
Not that I've seen, no.
Senator Fasco-Doe?
Thank you, Mr. Chairman. Jason, just to clarify, so are there three entities? So the cultivating department, and then the business who is dispensing or selling, and what's the other department you said?
Regulatory departments?
Who's testing?
Are you talking business facilities, or are you talking the regulatory state entities that are regulating the different aspects?
Well, I don't know. I just heard you talk about the cultivating step, and then the person who sells to the patient. And then was there another entity?
Yes. So there's the cultivator who grows the product, and then they typically can sell to a processor or to the retail dispensary directly their grown product. They would First, though, before doing that, would send samples to a laboratory to have it tested by a laboratory to ensure it complies with the state requirements. And then when they get that seal of approval, then they would send it on to the processor or the retail dispensary. The processor would take the raw material, process it into an edible or an oil or tincture, and then pass it on to either a distributor or directly to a retail dispensary. The distributor packages it, ships it out. The retail dispensary is the one that then ultimately sells it to the consumer.
And it's all with a tracking system from the start of the seed to
Yes.
the end. You know, what mother plant, everything is tracked in the testing, my understanding, and that's what other states are doing. Any further questions? Senator Hilscher?
Mr. Chair, under the employment discrimination, are there some best practices out there in other states that potentially spell out the workplace drug policy in light of medicinal cannabis?
Let's look into that. I think Andrew and I can look into that and see what other states that already have medical marijuana may have in place in terms of workplace drug policies for patients.
May I ask a
Go ahead.
Are there any provisions in either bill in regard to people maybe recently convicted for possession who had a condition? And I'm thinking of, I know of a couple of individuals who were Kansas citizens, potentially went to another state, purchased product, and then back in Kansas were arrested and convicted of whatever level of possession that is applicable. So are there provisions in either of these bills that address that situation?
No, there's no provisions that would rescind a conviction that somebody already has on their record for possession, even if they would have qualified, because convictions take place, it's kind of like a snapshot of what occurred at the time you were arrested and had possession and then were convicted. And there's no look back at those convictions under either bill.
Okay, Senator Fasco-Doe and then Senator Peterson after that.
Thank you, Mr. Chairman. Jason, you, in your presentation, you talked about 15% to minority businesses. Elaborate on that
Basically, it's a provision lifted from the Ohio Regulation Act that says ABC would have to issue business, at least 15% of the business licenses they issue would be issued to minority applicants.
in your definition of that minority, is that women? Is that black people? Is that, because minority, like I deal with some small minority and women-owned businesses. However, women, it's all women, but just curious, and if you want to get back with later on that.
Yeah, let me get back to you when I can look at that provision a little bit more closely. It is more specified in the provision as to what, and there are, it's not a blanket requirement if, of course, they don't get enough applicants for business licenses to meet that 15%. There's a caveat for that, but let me get back to the committee on more details on that.
Senator Peterson?
Thank you, Mr. Chair. Jason, on the top of page 12, you have the by January 2022 must be accredited by a national laboratory accrediting body. That is the same in both bills?
I believe so. I believe the laboratory that's getting the license to be a laboratory testing facility has to be accredited by a national laboratory accrediting body. I can double check on that, but I believe that's the case.
Thank you.
Okay, are there any further quick questions? Senator Hosher, one more.
Thank you, Mr. Chair. Can you just remind me, SB 315, where did that bill start and what was the pathway as far as where it ended up?
It was introduced at the very end of the session.
Okay.
And so it got introduced, I believe, during veto session, referred to this committee on like the second to last day of the veto session.
Yeah, that's a blur. Thank you.
Thank you. Any further questions? Not seeing any. Tomorrow, we're gonna have an overview, kind of where we're at on gaming, and then on Thursday, we're gonna have an overview of, all the election bills we passed, kind of where we're at, and some of the bills we got in committee. We probably will then the following week take this topic up with a hearing on a bill. Anything I bring forth and informational like this, we will probably move forward in the committee this year. We'll make the decision where this bill goes. These are the starting points of two bills. We'll probably have a hearing on the Senate Bill 158 that the House, I believe they had a bill, they amended into Senate Bill 158, and it got referred to this committee. That's not the final work product. I wanted everybody to at least have a good background of the bill and what's in it, be able to ask questions, when we do have the hearing on that bill, that everybody understand as we're going through it, and it'll probably be a 2 or 3 day hearing on the proponents, opponents, and neutrals. So I just want everybody to have background. We're going to dive into the same thing on the gaming bills and the election bills. And so I'm trying to figure out all the bills we got right now in the committee and figure out the hearings. But these are this is one of the earlier, we're going to start in next week. So, yeah, go ahead.
Thank you, Mr. Chairman. So are you going to be revisiting the sporting?
We're going to be discussing where we're at tomorrow on them bills. And I would like to see that subject wrapped up this year and be in the law if possible. So, any further questions? With that, we're adjourned until tomorrow. Good luck. Thanks.